So yes, very good afternoon. So very good afternoon. Today, we will have a 5-minute quick recap of what we have discussed in the previous class, and then we'll come to the today's class. So yesterday we talked about directive principles of state policy. So in which part they were mentioned? Part 4 of the Constitution. Are these directive principles originally there in the Constitution or added later? Originally there in the Constitution, they were not added later. So they were constitutional makers have itself thought that it is better to have these directive principles of state policy. Then what are these directive principles? What are these directive principles? When somebody asks you to explain in a layman term in single line, what are these directive principles? Directive principles of state policy are basically the directions issued by the Constitution to the government of the day. So for the 5-year ruling that they were doing, so they have to implement these principles whenever they are making the schemes, policies. So they have to incorporate these principles into their ruling. Okay. What is the main essence of this particular directive principles? What is the objective? So the objective is purely about welfare of the people. The directive principles mentioned about the welfare measures that the government have to take while they were in the government. Okay, fine. So then directive principles of state policy, are they justiciable or non-justiciable? They are non-justiciable. When compared with fundamental rights, these are non-justiciable. That means even though they were violated, even though they were not implemented, so one cannot enforce them through a court of law. Okay, so nobody can go to the court and implement these particular directive principles. Okay, so which article says you that these are not non-justiciable? Article 37, correct. Article 37 of the Constitution has clearly stated that the directive principles of state policy are not non-justiciable in nature or not enforceable in the court of law, but however, they are fundamental in the governance of our country. That is what is 37. What about 38? Quick revisions undalandi meeru. Okay, the moment you go home with your handouts, please do the quick revisions. Because these are basics, these are nothing actually. Okay, so next, Article 38 talks about concept of welfare state. So that means the state should promote or shall promote the welfare of its people and thereby securing its social, political and as well as economic justice to the people. Okay, what is Article 39A? Exact verbatim manam cheppalekapoyina, at least we need to be, to promote the equal justice and at the same time provide the free legal aid to the poor population. Okay. Accordingly, the Parliament have enacted which act? Legal Services Authorities Act 1987, which has established a body called as NALSA, National Legal Services Authority. So, okay, is it a constitutional body or a statutory body? Statutory body, because that was enacted through a statute that was made by Parliament. Okay. Who was the patron-in-chief of NALSA? Chief Justice of India is the patron-in-chief. Who is the executive chairman of NALSA? The senior most judge or whoever will become the executive chairperson. Similarly, at the state level, we have SLSA, State Legal Services Authority, which will be headed by Chief Justice concerned High Court of the concerned High Court. Who will be the executive chairman? High Court's senior member or senior judge will become the member of this particular NALSA. So fine. So NALSA implements which article of our Constitution? 39A of the Constitution. So 39A, is it originally part of the Constitution? No, it was later on added. When it was added? 1987. That was the Act, Legal Services Authorities Act 1987. 42nd Constitutional Amendment Act 1976. This is how they will give and okay, through which of the following acts the 39A was inserted. The first option will be Legal Services Authorities Act 1987, but wrong. It was 42nd Constitutional Amendment Act 1976, it has added. Can you tell me the other directive principles which were added through 42nd Constitutional Amendment? Okay, preamble was also amended, fine. Other directive principles, what I meant to say is, article number 39 was added, one important clause was added, 39A was added, 43A was added, 48A was added. We haven't discussed this 39, 43A, 48A, these things which we will discuss in the later on levels only. Okay, fine. Then Are there, from where we took these directive principles? From which country? Irish constitution. Okay, from the constitution of Ireland we took this from this. Who in turn took from where they took? Spanish constitution, correct. Even this is also important, and from where, which constitution we have taken, okay. Which part of the constitution resembles instrument of instructions? Part 4, directive principles resembles the instrument of instructions. Instrument of instructions are issued by, through which act? Instrument of instructions were issued through which act? Government of India Act 1935. So the same thing we resembled in this particular these things. Similarly, like objectives resolution passed by whom? This was the first class we discussed. Objectives resolution was passed by Jawaharlal Nehru, okay, and that became the modern day preamble, okay. So please don't skip the classes. So if you skip the classes, you will miss that continuity, okay. Now, and then we talked about important directive principles as well, like we talked about 39A, it is finished. We talked about 37, we talked about 38, and then we talked about even 40 as well. What is 40? What is article number 40 of the Constitution? These need to be on your fingertips, Andy, okay. From the previous classes, once you 46 or 40? Once you are very thorough with the previous classes, then only we will discuss the new things, or otherwise we will discuss again the old things. It will be a time waste, right? So ensure that no time is wasted. Okay. Article number 40 talks about village panchayats. Organizing the village panchayats and giving them more power so that they can work as the local self-governments. Article number 40 of the Constitution. Accordingly, 73rd Constitutional Amendment Act 1992 was brought into force, and a 11th schedule was added. And then, what is 46? What is Article 46 of the Constitution? So UPSC may not ask you which of the following articles, and the numbers may not be asked, but however these article numbers will be helpful for you to write in your mains exams. Okay, so if you argue with that accordingly, according to the Constitution of India, under Article 46 of the Constitution or under Article 40 of the Constitution, that will have a better impact. Okay, so that is how you should know. Okay, Article number 46 talks about the state shall promote educational and economic interests of scheduled castes and scheduled tribes. So, okay, and it has to correct the historical injustice and as well as the social exploitation that have been carried out to them. This is what is Article 46. So, where we discussed about the recent 10% EWS criteria was recently declared as unconstitutional or constitutional? Constitutional. In which particular case this 10% EWS was recently upheld by the Supreme Court? Janahit Abhiyan versus Union of India case. Okay. So have you collected your handouts? Collected or not collected? So please collect your handouts and please revise them, Monday, from the past 4 classes. So, okay, tomorrow we will ask only those questions. Then if I feel satisfied that you are okay, you are also on track, then we will discuss future things. So that is what is 10, because these are all very, very important and very basic, Sandy. 10% EWS reservation was recently upheld by Supreme Court in which of the following cases they will say. And if they give 4 cases, you will be completely confused and out of the race, because 1 mark can cost you 1 year for sure. Okay, it was Janahit Abhiyan versus in Union of India case. In this particular case, Supreme Court has recently upheld. Okay, 10% EWS is fine, it is valid. These are the statements of Supreme Court of India. Okay, and then there are the complete reservation policy we talked about. Like I said that we will discuss this complete reservation policy in our country, starting from most important case called as Champakam Dorairajan versus State of Madras, because the reservation concept has started with this particular case. And Champakam Dorairajan versus the State of Madras. Most important case from where we will start the discussion related to like what happened in Champakam Dorairajan, then what happened in Mandal Commission, and then comes Indira Sahani case. Okay, all these things we have to talk about. Like for example, S. Jarnail Singh case, Nagaraj case. Polity doesn't mean only articles of the constitution. Polity mean that articles of the constitution in combination with that of the laws made by parliament, and at the same time the judgments of Supreme Court. What have happened up till now, in an integrated way we have to learn. Or otherwise what happens is, you will miss majority of the things, and in prelims or mains you cannot answer the questions to the fullest extent possible when your knowledge is half knowledge. So that is 46. I hope you will tell 49. What is 49? What is Article 49 of the Constitution? No idea? Article 49 talks about the preservation of ancient monuments. Ancient monuments. Okay? The protection of the monuments, it is a duty of the state to promote these particular historical monuments. These are the things that we discussed yesterday. Done? Now let us today understand about what are the differences between the fundamental rights and directive principles of state policy. On one side we have fundamental rights, on the other side directive principles. First of all, common thing, both the fundamental rights and directive principles, if you talk about, whatever the objectives we gave in preamble will be implemented through fundamental rights and directive principles of state policy. Whatever the objectives like justice, social, economic, political, liberty of thought expression, faith, belief, worship, equality of status and opportunity, and finally fraternity, assuring the dignity of the individual and unity and integrity of the nation. All these objectives will be fulfilled through these fundamental rights and directive principles of the Constitution. That is similarity between both of them. When you are talking about difference, the first important difference is enforceability, or also known as justiciability, we call it as. Fundamental rights are justiciable in nature. So that means whenever these fundamental rights are violated, you can approach the Supreme Court of India under which article? 32 of the Constitution, and to High Court under which article? 226 of the Constitution. Okay, and then, but however on the other hand, directive principles are not legally enforceable. Okay, which article says this? Article number 37 of the Constitution says that the directive principles are not legally enforceable, but however they are fundamental in the governance of the country. That is the first point that we have written. Fundamental rights are directly enforceable through the courts, while DPSPs are not directly enforceable. Okay, Nanti? Second important is purpose. What is the purpose of giving fundamental rights and what is the purpose of giving the directive principles of state policy? So you already know purpose is basically fundamental rights means giving some basic rights to the people of our country, which also includes foreigners also. Okay, so because we give some rights to the foreigners as well. We will discuss all those aspects when we are discussing fundamental rights in detail. Okay, and then, but so it is basically telling the state that not to involve into the people's fundamental rights. So those are your restricted area, no-go area. That means you should not infringe upon the fundamental rights. You cannot take away their fundamental rights. Why? Because then immediately courts will come and restore them because they are legally enforceable. On the other hand, directive principles purpose is, it is basically giving the directions to the whom? Government. Please, when you are ruling for 5 years, it is your duty to follow these directions and take the welfare measures. Okay? When these directive principles are not violated by the government, then what is the remedy? When the directive principles of state policy are not implemented. For example, if I have the government and we won for 5 years, so okay, we said that our manifesto says that we will implement all DPSPs, and we take care of welfare of the people, and I said that I'll give employment, I'll give education, safety and everything, etc., etc. But the moment I started jumping onto the government, I'm not at all interested about these aspects. So now I have violated. What is the punishment? Correct. So again, the punishment for violating the directive principles to the people is that the people itself will not vote it again. So the government will not be voted again. That is the biggest punishment we are giving to the government. So the purpose of fundamental rights are, these are the basic rights given to the people by the constitution, and also warning, giving warning to the state that, hey, don't interfere in the rights of these particular people. So because we have established an organization called as Supreme Court of India, even if you violate the fundamental rights, then immediately Supreme Court will come into picture. Directive principles, on the other side, giving directions to state. So first one is enforceability, and the second thing is purpose. Fundamental rights will protect the individuals from the state encroachment. So state should not interfere, okay. But on the other hand, DPSPs will promote the social welfare of the people, and it gives directions to the state. These are the two important differences that you have to know about with respect to these things. Next is implementation. What about implementation? How fundamental rights will be implemented and how DPSPs were implemented. Fundamental rights, for example. Fundamental rights do not require any legislation for their implementation, but DPSPs do. What does it mean by? For example, article number 21 of the Constitution, right to life. Most important article. So no person's life and as well as personal liberty cannot be taken away by any other particular except by the procedure established by law. That means except by the procedure established by law, nobody's life and personal liberty should be taken away. So that means that is guaranteed under article number 21. Example, for example, if there was one college student, so for example, assume that on some drugs case, on mere suspicion, he was detained by the law enforcement authorities, okay, then immediately his article number 21 is violated. Illegal detaining of a person or arbitrarily detaining a particular person will be, then immediately article number 21 will be violated. What happens once a particular student or individual has been detained, then immediately their family members will approach the court saying that my son was illegally detained by the police. Why? On saying that some drugs case or something else case, he has been detained, but to illegally. Correct. Yes. So illegally detained. Then immediately court will say that court will issue a writ called as habeas corpus. Even in the movies as well we have watched this habeas corpus. Habeas corpus means, what is the, it's a Latin word which means bring the body. That means court will say to the police that you first bring the body. Of whom? Of that person who was detained. Bring that human being who was detained in front of me. Now I will tell whether that particular person is illegally detained or not. If really he has connections with the drugs or some terrorist related thing, then that is final. Okay, I will say that it is legally he was detained. But if he was not legally detained, illegally detained, then his fundamental right will be violated. Which fundamental right will be violated? Article number 21 will be violated. And whose duty is that to restore it back? Court. As a Supreme Court, I should restore his fundamental right again. That is how the fundamental rights will be violated. Now to implement article number 21, is there any law in our country or legislation in our country? Nothing. It will be implemented automatically. On the other hand, example, consider article number 39A. To promote equal justice and provide free legal aid to the poor population. This is what is 39A. So is it automatically implemented? No, it should be implemented by whom? By the Parliament. How it has implemented? Legal Services Authorities Act 1987. So that means this is the legislation which was enacted by whom? By the Parliament. So that means the concluding point is that for fundamental rights to be implemented, no legislation is required. It will be automatically implemented. But on the other hand, directive principles, if you want to implement any directive principles, it requires legislation and it has to be implemented through a legislation only. Okay. Example, article 39A, which says provide the free legal aid. That is just a direction. Now that has to be given effect. Given effect means a legislation has to be framed. Accordingly, Legal Services Authorities Act 1987 was brought up. Then Article 40, organize village panchayats. So in order to implement this, we brought up 73rd Constitutional Amendment Act 1992, isn't it? Fine. Then next one is like EWS reservation, article number 46. To implement this as well, we have made a constitutional amendment. So this is how you should understand that the concluding point, to implement fundamental rights, does it require any legislation? No, it doesn't require any legislation. On the other hand, directive principles, it requires a legislation. Okay, Nandi? Yes. Next one is suspension. Can they be suspended? Fundamental rights can be suspended during the times of emergency cases. Okay, there are three types of emergencies which have national emergency, state emergency and financial emergency. In the case of national emergency, these fundamental rights can be suspended, okay, except two articles that we will discuss later. But on the other hand, directive principles, can they be suspended? There is no need, right? Even though they are suspended, there is no point, right? For example, emergency, why we have to suspend fundamental rights? Let us take an example. Freedom of movement. Under which article? Article number 19 of the Constitution. Article number, now no need to bother about article numbers, so we will discuss them later again. We haven't discussed that article number 19 is freedom of movement. Okay, so freedom of movement, that means you can move freely throughout the territory of India. Nobody will stop you. Okay, it is your fundamental right. But assume that now there is a war going on between India and Pakistan. Okay, and on the areas of like Kashmir, Gujarat, these are Rajasthan, all these areas are now war prone in nature. Now you say that, so I want to just see the Dal Lake, or I want to just go to Srinagar. Why? Because it's my fundamental right. Under article number 19, these are the basic rights guaranteed by Constitution to me actually. And even we have courts as well that if my fundamental right is violated, violation means what happens? If I restrict you not to go, that's a violation. Okay, then immediately you will say that my fundamental rights are violated and you can say that you will approach the courts. But no, that is not possible because these freedom of movement will be immediately suspended when the national emergency is in force. On the other hand, directive principles, these are actually the directions to the government, right? So there is no need of suspension. So DPSPs will not be suspended, but fundamental rights can be suspended and will be suspended during the times of emergency. That is the point you should understand. Implementation, it doesn't require any legislation for fundamental rights, but it requires legislation for DPSP. Suspension, fundamental rights can be suspended during emergency, DPSPs cannot be suspended. Now it's the time for some of the important questions. Which part of the Constitution of India declares the ideal of a welfare state? In which part of the Constitution the idea of welfare state is discussed? Can you tell me? Directive principles of state policy. We have said that the concept of welfare state is mentioned under directive principles of state policy. Under which article? Correct. Article number 38 of the Constitution talks about the welfare state. So therefore here the answer will be directive principles of state policy. What was the part number? 4. Part 4 of the Constitution. Correct. Now the same thing we have written. Directive principles of state policy constitutes a very detailed economic, social and political program for a modern democratic state. They express the concept of welfare state. Part 4 of the Constitution from the articles 36 to 51 mentions these so-called DPSPs. This question? Correct. Which landmark decision of Supreme Court of India outlined the basic structure, doctrine of the Indian Constitution, and it's also known as the fundamental rights case? And the answer is Keshwananda Bharati case versus state of Kerala. Most important case andi. So okay, na, this has brought up something called as doctrine of basic structure. Doctrine of basic structure. What does it mean by? So that means who has the power to amend the constitution? Parliament has the power. Is it Parliament or Parliament alone has the power? Parliament alone has the power to amend the constitution. And so does it mean by it can amend any part just as if it wants? No. Some restriction has to be kept on the Parliament regarding its amendability power. That is restriction is called as basic structure. This was brought up by judiciary, by Supreme Court in Keshwananda Bharati versus State of Kerala. That means, so the Parliament using its power to amend the constitution can amend any part but except this so-called basic structure. It should not violate. Even if it violates, then immediately Supreme Court will come to the rescue and strike off that particular legislation and thereby protecting the constitution again. Yes, the same thing that we have written here. The Keshwananda Bharati case, also known as the State of Kerala and ANR versus Keshwananda, his full name and actually, was a landmark decision of Supreme Court of India. In this case, the court outlined the basic structure doctrine of the Indian Constitution, which holds that certain fundamental features of the Constitution are beyond the amending power of the Parliament. That means they cannot be amended. Let me tell you one example. One example is judicial review is one such example. Second example is India is a now Parliament cannot say that from tomorrow India is a Hindu religion or India adopts the Hindu religion or Christianity or Muslim. No, it should not do that because secularism is basically our feature of our constitution of our country and that's a basic feature. Clear? And then let's go to the next question. What are the remaining cases? That we will discuss Sunday actually. Okay, na? Because those questions, those things are like Golaknath versus Union of India. These are all very, very big and significant cases that have happened from 1951 to 2023 and matter. So, okay, lot many cases are there. Those are just exceptions. We will have a detailed sessions of all the important cases. So, okay, just reading case, this case is associated with this thing, this case. No, that should not be the way. Okay, so there is an order, there is a link between legislature and judiciary. That means legislature has done something, so and then judiciary has immediately acted something. Okay. Then, okay, we will discuss that particular portions later. Then, let's go to the next question. Can you answer this? Under which specific article of the Constitution of India is right to move the Supreme Court for the enforcement of the rights conferred by Part 3 guaranteed? Article number 32. Article number 32 talks about right to constitutional remedies. One can approach the Supreme Court under Article 32 in order to restore their fundamental rights and to High Courts under Article 226 of the Constitution. So therefore here the answer will be 32. Again, we haven't discussed 30, 33, 34. All these are all part of the foundation level we will discuss, Andy. So that each and every article, provision by provision, clause by clause we will discuss. Okay, and it has to be encompassed with the judgments of the Supreme Court as well. Read an article and associated judgment. Read an article, associated judgment. Then the story will be much more interesting rather than discussing a particular case in isolation. Okay, so therefore here the answer is Article 32. You can see the same matter that we have written here. Article 32 of the Constitution guarantees the right to move Supreme Court of India by appropriate proceedings for the enforcement of the rights which are conferred by Part 3 of the Constitution. Part 3 deals with fundamental rights which are actually individual rights that are protected and guaranteed by the Constitution. Okay, fundamental rights are taken from United States of American Constitution. We have taken these particular fundamental rights. Okay, can you answer this? Okay. So which of the following writ deals with bringing the body of a person before the court to ensure that the person is released from the unlawful detention, and that is what is habeas corpus. While we are discussing Article 32, while we will discuss Article number 32, we will discuss all these writs. We call it as writs. And we will study about this, the writ jurisdiction. Okay, Nandi? As of now, only habeas corpus, just focus on habeas corpus. Habeas corpus means bring the body off. Whenever a particular person has been illegally detained, just bring them back. So now the court will decide whether that particular person is illegally detained or not. Okay. The same thing we have written. The habeas corpus is a legal remedy that deals with bringing the body of a person before the court to ensure that the person's release from unlawful detention or imprisonment. This writ is used to protect an individual's fundamental right to personal liberty and prevent any arbitrary or illegal detention. So that means, for example, if you were illegally confined, then you have habeas corpus. You can request the court, please issue habeas corpus. Okay, that is how. These are all practical things, and these are all not theoretical. These are the things that we have. We have these fundamental rights. Nobody can stop us. Nobody can take away our fundamental rights. Okay. Can you answer this question? Only 30 seconds time. Okay. Any other options? C and A, not enforceable by any court. Okay. So everybody is same with the same option? Or should you have to read again? No need? C will be the answer? Yes. Our basics are same, and DPSPs of state policy are non-justiciable. Non-justiciable means not enforceable by any court of law. So the first option says enforceable by any court, enforceable by Supreme Court, enforceable by High Courts, not enforceable by any court. That will be the answer. Okay. This is how they will tweak the words. The same thing. The provisions which are contained in Part 4 of the Constitution of India titled DPSPs are not enforceable by any court. This means citizens cannot approach a court of law to enforce these principles directly. But however, they have a very big weapon with us, to voting power. Use that. Just throw the government out. Then, again, this is the same question in a different format. Earlier we gave the parts, now we give the part numbers. Okay. So part 4 of the Constitution deals with the directive principles. What is part 1? Union and its territory. What is part 3? Fundamental rights. Part 2? Citizenship. Correct. So part 4. Part 4 of the Constitution titled DPSPs, this part laid down the principles and guidelines for the government to achieve the social, economic and political justice for the welfare of the people. The concept of welfare state is embedded in the directive principles, making the part 4 as a correct answer. This question? Again the same question, but now they focused on article 38. Correct, Andy. So, article number 38 of the Constitution deals with the concept of welfare state. It is basically the duty of the state to promote the welfare of its people and thereby secure its social, economic and political justice of the people. This one? Okay. Which article of the Constitution seeks to promote equal justice and provide free legal aid to the poor population? And the answer will be 39A of the Constitution. Now, does this article require any legislation to be implemented? Does this article require any legislation to be implemented? Yes. And what was the legislation to implement this article? Can you tell me the legislation that was enacted in order to implement this article? NALSA is the body that was created. What was the legislation to do that? Legal Services Authority Act 1987. That was Legal Services Authority Act 1987. What is the difference between the bill and act? Yesterday we talked about statutory and constitutional bodies. Constitutional bodies means those bodies which were created directly by the Constitution. Statutory bodies means those bodies which were created by the Parliament by law. What is the difference between bill and act now? Because I am using the words here act. What is the difference between a bill and as well as act?
Bill is a it's like proposal.
It's a proposal, correct. That means
Act
just
is an
act means after receiving the,
and I think act is like Ncert.
yes, after receiving the president's assent. So the bill has to be first introduced, be it either in Lok Sabha or Rajya Sabha. It has to pass to the other house, then it should come to the president, and president should sign it. After the president's signature, it will become the act. Okay, it has to be published in the official gazette of India, then it will become an act. Or otherwise, up till then, its stage is only bill. Be it a money bill, be it a constitutional amendment bill, or an ordinary bill, whatever the bill, it's a bill only. Wherever you see the word called bill, it's a proposal. Wherever you see the word called act, that means it has passed all the stages and it came up to the act. Now, can you tell me what might be the name of this bill, of this act? What might be the name of this particular act? What will be the bill name? Bill name is simple. Legal Services Authorities Bill 1987. Okay. So this bill was maybe introduced initially in the Lok Sabha, then passed to Rajya Sabha, then got the president's assent. President has given his assent. Yeah, this bill is required. Then it became an act, and thereby it implemented Article 39A of the Constitution. Thereby NALSA created, SLSA created. That keep on going. Therefore, here the answer will be 39A. The same thing we written here. Article 39A seeks to promote equal justice and free legal aid. It directs the state to ensure that the operation of legal system promotes on the basis of equal opportunity, and further requires the state to provide free legal aid through suitable legislation or schemes to ensure that opportunities are not denied to any citizen by reason of any economic or disabilities. Example is poverty. So that means, for example, any person because of poverty, if he is unable to hire a lawyer, so then an injustice will be carried out to him. In order to correct that, we brought this. Yes. Can you answer this question? It requires some thinking, some thought process need to be carried out. You should try it logically. Okay. Both? Both 1 and 2? Any other opinion? Only legislative function, okay. Okay. Only legislative, huh? Okay. So, what is the objective of bringing the directive principle of state policy exactly? What is the objective of? What are fundamental rights? What is the objective? Fundamental rights, objective. Constitution. Think it from the Constitution's perspective. These are the rights that we gave to the people, and we are asking the state. State means both executive and legislature. Okay? We are asking the state, state, don't involve in these particular rights. That means there is a limitation upon you. Don't involve in the fundamental rights of the people. Don't try to take away those fundamental rights. You cannot do that. Okay? Because I have also established Supreme Court as well, which will always see whether you are taking away the fundamental rights or not. That means this particular constitution is acting on the limitations, providing some limitation on the power of the state, not on with respect to fundamental rights. Now think about DPSPs. Directive principles means it is asking the government, do something to the people. Okay, giving both to the executive and legislature as well. It is not limiting. It's not saying that don't do this, don't do this. It is saying that do this, do that particular thing. Provide free legal aid, organize village panchayats, promote the health, educational and economic interests of weaker sections. Always it is saying that in a positive way, do that particular thing, do that particular thing. It's not saying in an opposite way, don't do that, unlike in fundamental rights. In fundamental rights, we have seen that I have given them right to life, don't interfere. I have given them freedom of religion, don't interfere. I have given them freedom of movement, don't interfere. And that means always limiting the power of the state in fundamental rights. Now tell me the answer of this question. No idea? Okay, fine. So, with reference to Constitution of India, the directive principles of state policy will constitute the focus on this word, limitations. Do directive principles limit the government, limit their functions? It encourages basically these particular things in order to do that particular way. So that means legislative function or executive function, on none of them it will not act as a limitation. Ideally, if the question is instead of directive principles, if the question is fundamental rights, then it acts as a limitation on both the legislative functions and executive functions also. Why? Because they have to keep in mind that I should not violate. That means it's a limitation on them, don't violate. But on directive principles, no need to violate, nothing. Follow this principle, follow that principle. I am giving you the directions. So that means directive principles of state policy are actually the positive in nature, but fundamental rights are negative in nature. Directive principles encourages the state, fundamental rights limits the state. Clear? So therefore, it will not act as a limitation upon both executive or legislative. No, it will not act any on limitations, it will not impose. But if the question is fundamental rights, yes, it will act as a limitation on both executive action and legislative action as well. So that means they cannot perform just like that. They should keep in mind that they should not violate the fundamental rights. That is the answer of this question, Andy. So this is how they will ask. Adanamata. So okay, that is how they will frame the question. This was exactly the question that we picked out from UPSC. In 2021 or 2020, maybe this question was asked. See how you need to think about. So finally, the final conclusion is that directive principles of state policy are just encouraging in nature. They are positive in nature. They will not limit executive or they will not limit legislature. Don't do that, don't do that. No, it is the fundamental rights which will do like that. That you should understand. Who knows? Tomorrow they will just replace the same question and they will bring with fundamental rights and ask the same question. So now again you think that they will not, then both will be the answer. Your thought process should not be like that. On that day we talked about directive principles. Legislative and action and executive action, they both are not, they not limiting. So there might be the chances that fundamental rights as well will not limit the executive or legislature. No, fundamental rights will be a limitation on executive and legislature. Directive principles of state policy will promote, encourage these things. Then this question. So that means until and unless you understand it correctly, holistically, then only you will answer the questions. Or otherwise it will be very, very difficult and you can't even understand the question itself. That is the main problem here. See, don't try to complicate. Whatever you know, just tick mark it. See, the question. With regard to directive principles of state policy, forget about the first point, we will talk about it. Second point, the provisions which are contained in directive principles are not enforced by any court. Is it true or false? Is it true or false? Correct. It was true because they are not enforceable by any court. Correct, I finished. Then, the principles spell out the socio-economic democracy in our country. So that means they will promote the social democracy. They will promote the economic democracy in our country. It appears to be logically true. Correct. Both are correct statements only. Okay. So the directive principles of state policy promotes the social and as well as economic democracy. But whereas fundamental rights will promote the political democracy. This we will discuss when we are discussing more about fundamental rights and DPSPs. Don't try to burden yourself now itself. Answer this question. Previously we talked about judicial review, which is one of the basic feature of our constitution. This is the level you should command. First one, your combined opinion, or everybody has their own opinions? First of all, can you eliminate some of the options? First try to eliminate. Which options you can eliminate? This might never be the answer, this will be. Can you eliminate? The power of judiciary to review all the legislative enactments before they are assented to the president. You have eliminated. Okay, then you are left with 3 options. Then, sorry?
Yes, sir.
You are eliminating it, or that will be the answer? Eliminate. Okay. Last one, you will eliminate last one as well? Answer, okay. Okay, you are saying B will be the answer?
B answer, eliminate.
Eliminate B.
Answer C.
Answer C. C, okay.
Answer D, sir.
Answer D, okay. So then should I take A? Okay, fine. I'll take? Should I take B? Okay, forget about this question. What happens in judicial review? What happens in judicial review? For example, Parliament have brought up some law. Okay, let us assume that it has brought some amendment to the Motor Vehicles Act. Okay, what is this Motor Vehicles Act 1988? The amendment says that women are not allowed to drive. Women are not allowed to drive. This is the law. Now we as a parliament, so we drafted that particular law, and this law says that women are not allowed to drive from tomorrow. Okay, fine. This law was given to the Rajya Sabha. Rajya Sabha also passed it. It went to President. President also gave his assent. Yeah, okay, women are not allowed to drive. That is fine. So now it became an act. Bill became immediately an act. Then tomorrow, so when one of the female employees is going to her office, so she was now stopped by traffic constable and say that a challan has been filed against you. Why? Why? Because she says that, she argues that I have a valid driving license with me, I have helmet with me, pollution certificate with me, okay, and everything is there with me. Why you are levying a challan against me? She says that because yesterday Parliament passed a law which says that women are not allowed to drive, and now you came up with your scooty, so therefore now a challan has to be levied against you. You have to pay 1,000 rupees fine. Now she feels okay, she will pay 1,000 rupees. What she will do? She will say that, what is this? My fundamental right is violated. Why you are discriminating only women? If a particular law is there, it has to be equal to both men and women. Why only women are banned? Ban men as well. If you are not banning men, then revoke the ban on women as well. We both are same, right? Then immediately she will approach to where? Supreme Court, saying that my fundamental right is violated. Then Supreme Court will ask only one question. What happened? What happened? Yesterday Parliament has made a law, and it has banned the women from driving. That is discriminatory in nature, and it is against my fundamental right, and it is against the Constitution. Then Supreme Court will say that, acha, is it? Then just they will ask to bring that particular law. Okay, whatever the law that banned the women from driving, bring that particular law. It will take that particular law on one hand, and on the other hand, it will take the Constitution of India. So on Constitution of India, it says that equality before law, everybody has to be treated equally. But on the other hand, in this particular law, say that women are not allowed to drive. That means whatever the law that is made by Parliament is against the Constitution. Now that means whatever the law that is made by Parliament is unconstitutional or against that of the Constitution. What Supreme Court will do? Supreme Court says strike off this particular law and uphold the Constitution of India. That means whatever the laws that are made by Parliament in judicial review, its constitutionality will be checked. That means whether it is in sync with the Constitution or not, is it complementary with the Constitution or not, or is it against the Constitution or not. Now can you answer? Correct. That is the answer, Andy. Correct. Judicial review means any law, not only law made by Parliament, it is executive order as well. Okay, whether are they in sync with the constitution or not, are they complementary with the constitution or not, then only pass it or otherwise fail it. One more point you should understand, that judiciary will not see all the laws whichever coming to the, once they pass the president's assent, it will not go to the judiciary. Okay, not all the laws, because what happens is that the judiciary will become the ultimate authority, and once the law cleared from there only, then only it's like testing team, the development team and testing team if you consider. So don't consider that judiciary as a testing team. It is not like that. Only whenever a particular law is challenged by a person like you, if you take that particular law and if you approach the Supreme Court and say that this law is violating the constitution, example in this case, the female employee took that law and went to Supreme Court. If she didn't take that law, if she is not complaining, nobody has complained, everybody is happy, okay, women are banned, no worries, and if everybody is ready to pay 1,000 rupees fine as well, then it will run continuously it will run. Okay, so Supreme Court doesn't bother about. When it should bother, when the people's fundamental rights are violated, when they complain to me, then only I will act, or otherwise I'll keep silent. Understand? So judicial review means, so that is the reason judicial review means, that is the reason. Now this is the most, for the parliament, this is the most hated thing actually, isn't it right? In parliament we have some 545 members in Lok Sabha, 250 members are there in Rajya Sabha, and we all decided, president also gave the assent. Parliament, when Supreme Court with the judges of 5 or 4 judges, they are saying that just take out that law is unconstitutional, then immediately parliament's ego will be hurted. Okay, so that's how they try to escape from this judicial review. And then Supreme Court said in basic structure that this judicial review is also part of the constitution. Basic structure of the constitution. You cannot take away the judicial review. Okay, so therefore the answer is the power of the judiciary to promote the constitutionality of laws and executive orders is the answer here. Can you answer this question? Again, it will be an easy one. (49) of the Constitution. So there is nothing in these articles to think, unlike the previous questions. So there is nothing. It is article number 49 of the Constitution. Then this question. Let us see the other opinions as well. Directive principles, Pakka? Okay. Yes? Directive principles. Any other answers? Fundamental rights? Or maybe fundamental duties? Or maybe fundamental rights and fundamental duties, because those were the left out options, right? Fine. What is Article 37 of the Constitution? The directive principles of state policy are not enforceable in a court of law, but however, they are fundamental in the governance of our country. So that the government has to keep in mind and accordingly it should act. That is what they are asked. Which of the following are fundamental in the governance of the country? Directive principles of state policy are fundamental in the governance of the country, and it was mentioned in Article 37 of the Constitution. This is direct, straightforward question matter. These are like low-hanging fruits. Done? Bas. We will stop there. Fundamental duties we will discuss tomorrow one day. Okay, na? So up till now you have understood the directive principles from the beginning to all the important questions that we have. Tomorrow we will start discussing the fundamental